use 21-0375 will be continued to the October 25, 2021 Land Use Hearing Officer meeting, and that's at 10 o'clock in the morning.
That then brings us to Section A of our agenda, which are the published withdrawals and continuances. Item A1, Variance Application 21-0902. Applicant is David Wright. This application is out of order to be heard and is being continued to the October 25th, 2021 Land Use Hearing Officer meeting. Item A2, Special Use Application 21-0915. The applicant is Regional Properties Incorporated. This application is being continued by staff to the October 25th, 2021 Land Use Hearing Officer meeting. Item A3, Special Use Application 21-1001. The applicant is David Mechanic. This application is out of order to be heard and is being continued to the October 25th, 2021 Land Use Hearing Officer meeting. Item A4, Variance Application 21-1054. The applicant is NRS LLC. This application is out of order to be heard and is being continued to the October 25th, 2021 Land Use Hearing Officer meeting. Item A5, Variance Application 21-1116. The applicant is Hydrologic Distribution Company. This application is out of order to be heard and is being continued to the October 25th, 2021 Land Use Hearing Officer meeting. And finally, item A6, Variance Application 21-1123. The applicant is David Wright of TSP Companies Incorporated. This application is out of order to be heard and is being continued to the October 25th, 2021 Land Use Hearing Officer meeting.
Thank you, Mr. Hisney. All right, before we get into the hearings, I would like to announce some procedures. And first of all, if you have any devices on you that make noise, please silence those. The agenda consists today of items that require a public hearing by a hearing master. I will conduct a hearing on each item today and will submit a decision within 15 working days after the conclusion of today's public hearing. My decision will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of the direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure, and I will take evidence, but will exclude evidence that is irrelevant or immaterial or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil action. The order of presentation today will be for variances. Mr. Hisney will call the case. Then County Development Services will have 5 minutes to present its report and findings. The applicant and applicant's witnesses will have 15 minutes to present the proposal. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. And county staff will have 5 minutes to present any amended findings or comments. Then the applicant will have 5 minutes for rebuttal and summation. For special uses, Mr. Hisney will call the case. Then the applicant and the applicant's witness will have 15 minutes to present the proposal. County Development Services will have 5 minutes to present its report and findings. And then the Planning Commission will have 5 minutes to present its report, its finding of compliance or non-compliance with the comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. And opponents will have 15 minutes to present arguments against the proposal. County staff will then have 5 minutes to present any amended findings or comments, and the applicants will have 5 minutes for rebuttal and summation. The 15 minutes that are allotted to proponents and opponents is the total time among them. So if there are several persons who wish to speak, the 15 minutes will be distributed among those persons. If there are a number who wish to speak and you have a single spokesperson to represent your views, that would be fine. When you come to the microphone to speak, please first state your name and address for the record. The meeting is being recorded, and so please be sure to speak into the microphone so your testimony can be recorded. When you're finished speaking, please see the clerk to my right here to sign in for the record. Now we will hear from the county attorney's office regarding procedures for appeal.
Good morning. This is Mary Dorman from the county attorney's office. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside of the record made at today's public hearing. Any evidence presented to the appeals board that is outside the record created at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action then is for you to write down any comments you make today and repeat them to the appeals board.
Thank you. All right, all testimony taken today must be under oath. So if you plan to speak today, please stand if you're able and raise your hand and I'll swear you in. And if there's anyone online who plans to speak, please also present yourself to be sworn in. All right, do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. All right, Mr. Hisney, would you please call the first case?
So on today's agenda, we have no vested rights, no fee waiver requests, no remands, no reconsideration requests, and no site development variances, which then takes us to section G of the agenda, which are sign variances, and we have two cases. First one is item G1, application number 21-0838. The applicant is Sign Systems and Graphic Designs Incorporated. The request is for a sign variance. Staff findings will be presented by Kim King.
Good morning. Kim King, Development Services. The applicant is requesting 2 setback variances and a variance for additional square footage for a new monument sign located at 13618 North Florida Avenue for Tyrone Village Mobile Home Park. Per section 70300C3C of the Land Development Code allows up to 2 monument signs at 25 square feet per side, 50 square feet total per entrance to a mobile home park. Per section 70300C1C requires a monument sign at 10 feet high have a 21-foot setback from the right-of-way line. Per section 70300C1B requires any monument sign to have a 10-foot setback from any side yard property line. The first variance request The applicant is requesting an additional 28 square feet of sign area in order to have a maximum of 30 square feet per side, 60 square feet total for a new monument sign. Variance number 2, the applicant is requesting a setback variance of 11 feet from the right-of-way line and 9 feet from the side property line to the west. This would allow the monument sign to have a 10-foot setback from the right-of-way line and a 1-foot setback from the side property line. And that concludes my report.
Thank you. All right, is the applicant here? Please come forward.
Hi, my name is Sean Conkle with Sign Systems and Graphic Designs, 5031 West Gray Street, Tampa, Florida. So essentially, we are requesting a sign variance for two different reasons. One is, as Kim King was stating, the property has a 1 foot, we're requesting a 1 foot setback from the side property line as well as a 10-foot setback from the front property line. Essentially, there's no other place to place the sign without going in the middle of the driveway, which obviously is not feasible. The other variance we're requesting is basically a larger sign than as Kim King stated, that the code requires to allow for visibility, because it is a mobile home park, a 55+ mobile home park. So for emergency vehicles and so forth, we'd like to have the sign larger to be seen. There is a lot of landscaping and shrubbery from a neighboring property, so which is why we're requesting it to the base of the sign to be 8 feet above, to where it can be visible and seen.
Okay, anything else?
No, ma'am.
All right, so just to make sure I understand the numbers, you're requesting an additional 28 square feet of sign area.
Correct.
So for a maximum of 30 square feet per side, so 60 square feet total.
Correct, yes.
Okay. And then setback variance of 11 feet. So how close to the right-of-way line will it be then?
Well, essentially 10 feet off the road. No part of the sign will be any closer than 10 feet.
And 9 feet from the side property line to the west.
Correct, requesting a 9-foot variance. Essentially, the way the property is positioned, they don't have a whole lot of frontage on Florida Avenue there. So the sign, there's really only 1 or 2 places it could either go to the north or to the south of the entrance there. To the north is blocked by the neighboring property there, and the south side is where the sign was existing before they were asked to remove the sign. Unfortunately, the only position to put it without putting it in the middle of the road places the sign to where it would be 1 foot set off the property to the south.
Okay, and I understand there was some taking or widening of the right-of-way at some point?
Correct. To be honest with you, I'm not as familiar with what took place back then. I believe their lawyer was here and could speak on that behalf possibly, but they know more about the past history. But yes, there was a widening of Florida Avenue, which forced the sign to basically was a lot closer to the road. I believe it was just a couple feet off the road at that time, and they were asked to remove it.
All right, is there anything else then?
No, ma'am.
Okay. All right, thank you. Be sure and sign in with the clerk here. All right, is there anyone here or online who wishes to speak as a proponent for this request, in support of this request?
Dory Johnson with Next Day Signs.
Yes.
Yes, so Tyrone Village is my customer. Sean's representing us for the variance application. And I might reiterate some of the things that you guys have already covered. I just wanted clarification if that's okay. So the roadway was widened. The side that they had previously was actually 140 square foot. It was enormous, and it was right on the property boundary. So the code enforcement had asked them to have that removed. Their property set up a little bit wonky in the sense that the only thing that you can see from Florida Avenue is their driveway. The properties that bounder them on either side have the linear frontage. Their linear frontage is back behind their neighboring properties. So the property itself is relatively large and supports what code would allow for a much larger sign. Unfortunately, it's just not on Florida Avenue. They don't have enough room on either side of the drive to build the sign per code, which is why we're requesting the side variance. The one side that we would like to erect the sign is up against a parking lot. There's nothing there other than asphalt. The other side is covered with brush and trees. So it makes the sign very difficult to be visible even 20 foot from this driveway in either direction, heading north or south. Again, the property is 55 and up. So we do have major concerns for emergency vehicles locating the property, as well as the people that own and live there. So we do request the side setback variance, the front setback variance, as well as size for visibility. We studied this for quite a ways and quite a while to figure out best placement for visibility and legibility. And unfortunately, due to only having that driveway as road frontage, this is about the only location that you can put a sign that you can see, unless you bring it closer to the road, which may be more of an obstruction. Also the south-facing neighbor of this property has a very, very large pylon that blocks a lot of visibility as well for this property.
Okay, anything else?
No, that's all. Thank you.
All right, thank you very much. All right, is there anyone else who wishes to speak in support of this item? Is there anyone here or online who wishes to speak in opposition to this item? Okay, don't hear anyone. Anything further from Development Services?
No, that's all.
Okay. Applicant, did you have anything further you wish to add? All right, thank you. All right, then we'll close the hearing on variance 21-0838.
Our next case is item G2, application number 21-1122. The applicant is Seminole Presbyterian Church in America Incorporated. The request is a sign variance. Staff findings will be presented by Kim King.
Kim King, Development Services. The applicant is requesting a setback variance and variance for additional square footage for a new monument sign located at 6202 North Himes Avenue for the Seminole Presbyterian Church. Per section 70300C3B of the Land Development Code allows a residential support use to have a monument sign at 16 square feet per side, 32 square feet total, with a maximum height of 8 feet. Per section 70300C1C requires a monument sign at 8 feet high have a 19-foot setback from the right-of-way line. The first variance, the applicant is requesting an additional 28 square feet of sign area in order to have a maximum of 60 square feet total, 30 square feet per side for a new monument sign. The second variance, the applicant is requesting a variance of 6 feet, which would allow the monument sign to have a 13-foot setback from the front right-of-way line. And that concludes my report.
All right, thank you. Is the applicant here?
Thank you. My name is James Ullery. My address is 2170 Sunnydale Boulevard, Clearwater, Florida. I am with LED Tampa. We are the sign manufacturer that is working with the church on this project. And I would like to give a description of, this is somewhat of a unique situation. The church has an existing sign that has been in place since 1995. And the existing sign is a 32 square foot sign. And so the request from the church is to take and leave the sign in the same spot, utilize the existing footer, utilize the existing construction items, and simply remodel that 32 square foot sign and put a new identification sign on the top and an electronic message display on the bottom. So unfortunately, the current code that's in place when we apply for a permit says that sign must be reduced from its existing sign to 16 square feet per side. So our variance is to seek a variance to keep the size of the sign the same. Therefore, in order to do that, variance must be considered.
Okay, and so you're not increasing the sign. The new sign will be larger than the existing sign, right?
It will actually be 2 square feet smaller per side. But from a person driving down the road or looking at the sign, the new sign is the same as the old sign
Mhm. Okay.
in the same place. So our goal here was not to dig up the ground. We're trying to save customers some investment in
All right. And how long had that original sign been there?
1995.
Okay. All right. Anything else, sir?
I have nothing else. I have the representative of the church. If you would like to hear from Mr. Randy Johnson, he's here. That is, Randy, would you like to speak? Okay,
Okay. Did you have anything else to add in addition to this testimony? Please come forward and put your name and address in the record.
My name is Randy Johnson, 6307 Nicky Lane, 33625. I just want to say that we as a church bought the property in good faith and have the sign there. We have since changed the face of the sign to have our church's name on it rather than what was originally there. But whenever we want to announce special events or do anything else, we end up having to put temporary signs up and other things. And so we're really trying to make this maybe less of an eyesore. We're trying to be a good neighbor. And so the idea behind going with the digital sign is it gives us something where we can adjust what the signal is and what's going on. But our intent all along when we met with LED Tampa was to keep the same sign size and location, excuse me, so that we're not making modifications. So it should essentially look the same, only it'll be nicer.
Okay.
Thank you.
All right. Thank you. Please sign in for the clerk, both of you. Thank you. All right. Are there any persons here who wish to speak in support of this item? Any proponents here or online? All right. Are there any opponents here or online wish to speak in opposition to this item? Okay. All right. County Development Services, anything further?
Nothing further.
All right. And applicant, anything further to add? Nothing? Okay. Thank you. All right. This will close the hearing then on variance 21-1122.
That concludes section G of our agenda and takes us to section H, which is the general variance request. First case is item H1, application 21-0803. The applicant is Douglas Negron. They are requesting a variance to lot development standard. Staff findings will be presented by Steve Beachy.
Steve, you're muted.
Good morning, Development Services, Steve Beachy. The applicant is requesting setback variances for an existing dwelling to accommodate a proposed two-lot subdivision of a property zoned ASC 1. Per Land Development Code 60101, the required minimum rear yard setback in the ASC 1 district is 50 feet. The existing home on the subject property will be located on the proposed parcel 1 and will not meet the required rear yard setback from the new lot line created by the subdivision. The applicant requests a 5-foot reduction to the required 50-foot rear yard setback to allow a setback of 45 feet from the proposed south property line of parcel 1. The second variance is for the front yard of the same lot. The zoning for ASC 1, the setback requirement is 50 feet for the front yard. The existing home on the property does not meet this requirement. The applicant requests a 3-foot reduction to the required front yard setback to allow a setback of 47 feet from the north property line. I will note in the findings, the subject property is accessed from Green Meadow Drive on the north property line. Therefore, the required front yard is along the north property line, and the required rear yard is along the south property line, and the required side yards are along the east and west property lines. That concludes my comments. I'm available for any questions.
Thank you, Mr. Beachy. All right, we'll hear from the applicant. Please come forward.
Morning.
Good morning.
My name is Jose Maldonado. I'm representing Ms. Jamil Gonzalez, who is the owner of the property. Douglas Negron is a surveyor who couldn't be here today, so that's why I'm here. It gets a little bit technical for me to explain all this, but pretty much we're requesting those 2 variances because it's like a 3 feet and a 5 feet variance.
Can you hold just a second,
Yeah,
please?
excuse me. Yeah, we're checking to see who the authorized representative is.
Mhm.
Hold on.
I have an affidavit if you need it.
Sorry. Right, it's the authorized waiver. All right, did you bring an affidavit from the property owner to authorize you to
Yes, I
speak
do have it
today?
with me.
Okay, all right, be sure to please turn that into the record.
Sure.
You-
You want me to do it now or afterwards?
Madam Master, you want to see it?
Yes, please. Thank you. Sorry. All right, so this is an affidavit to authorize agent. And this is from Yamil Gonzalez, the property owner. And you are Mr. Maldonado?
That's correct.
Jose Maldonado?
That's correct.
Okay. All right, we'll put this in the record. All right, thank you very much.
Yes. She couldn't be here. She's an elderly lady and the surveyor couldn't be here. And I'm the person interested in purchasing to build a home there.
Okay.
It gets a little bit technical to explain all these variances, but I think Mr. Beachy did.
Okay. And can you just talk a little about the property's size, its shape, what you're doing with it? Why is the variance necessary to accomplish what you're doing?
Because it doesn't meet the standards at 50 feet. That's the one I can understand and explain from her property to when you divide the lot. The lot is a form of like a rectangle, sort of speaking, and it's at 300 feet roughly east to west, and that lot's going to be split in half, pretty much. And that second lot, which is called Lot B, that's where I plan to build a home, God willing. The owner has no issues with the variances.
Okay. And is this the only way feasible to split the property to make 2 lots with it?
That's to the best of my knowledge. I'm not a surveyor, but yes.
All right. Do you have anything further to add?
No, we want to build a home?
Okay. All right. Well, then I need you to sign in with the clerk
Sure.
here, please. And thank you.
Thank you, ma'am.
All right. All right. Is there anyone here who wishes to speak in support of this item? As a proponent of this item? Anyone here or online who wishes to speak in opposition to this item? Okay. All right, County Development Services, anything further? Mr.
Nothing
Beachy,
further.
anything?
Nothing further, no.
All right, thank you. And applicant, did you have anything further? Okay, you do not. All right. This will close the hearing then on variance 21-0803.
All right, next case is item H2, application 21-0935. The applicant is Anthony and Britt Diaz. They're requesting a variance to accessory structure regulations. The staff report was prepared by Kevin DeFrank, but I'll present the findings at today's hearing. The applicant is requesting a setback variance for a proposed accessory structure on a single-family lot zoned RSC6. The Land Development Code permits accessory structures that are 15 feet or less in height to occupy required side yards, provided they are no closer to the street than any part of the principal building on the same lot, and that the structure is set back a minimum of 3 feet from the side lot line. In the subject case, the proposed accessory structure will be closer to the street, Saltwater Boulevard, than a portion of the single-family home on the lot. Therefore, it must meet required side yard setbacks of the RC district, which is 7.5 feet. The applicant requests a 4.5-foot reduction to the required side yard setback to allow a setback of 3 feet from the west lot line. That concludes my findings.
All right, thank you, Mr. Hisney. Is the applicant here, please?
My name is John Tate. I reside at 18208 Keystone Grove Boulevard, Odessa, Florida. I'm here representing the homeowners, Britt and Anthony Diaz, as their landscape contractor and general contractor. The Diaz's have requested a 600 square foot accessory structure to be built on their property. I hired a architect licensed in the state of Florida to assess the possibility and feasibility of such. He prepared the plans. The plans were uploaded to the Hillsborough Building Department, and we're here today because of the aforementioned setback requirement. We have explored extensively other possibilities of putting this scale of building on the site. None of those were acceptable. The building would have to be shrunken in size, which would reduce the utility of it. The building will not be visible from the street, and it will not be more than 12 feet tall.
Okay. It appears on the survey that this building will have a kitchen.
Yes.
What's the use for this building?
I'm sorry.
What's the use for this building?
It's a lanai structure, essentially an outdoor lanai.
Oh, I see. Okay, it will not have living
It will
space.
not have any bedrooms. It will not be a residence.
Okay. Thank you. I'm just looking at the survey. All right, do you have anything further then?
I do not.
Okay.
Thank you.
All right, thank you. Please sign in with the clerk. All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Then Development Services, do you have anything further?
No, ma'am.
All right, and applicant, do you have anything further you wish to add? No, okay, thank you. So that will close the hearing on variance 21-0935.
Our next case is item H3, application 21-0938. The applicant is Dwayne Wilson. They're requesting a variance to accessory structure requirements, accessory dwelling requirements, lot development standards, and fence requirements. Staff findings will be presented by Steve Beachy.
Good morning again, Steve Beachy, Development Services. The applicant is requesting multiple variances for an existing home, fence, accessory structure, and accessory dwelling on a property zoned ASC1. Per Land Development Code, Section 60702, fences over 4 feet in height shall not be allowed within a required front yard that functions as a front yard. The applicant requests a 2-foot increase to the permitted fence height to allow an existing 6-foot high fence in the front yard along Timber Ridge Drive. The applicant also has 2 shipping containers located in the front yard and is seeking to permit them as an accessory structure. If granted a variance for their location in the front yard, per LDC section 60101, minimum front yard setback of 50 feet and minimum side yard setback of 15 feet is required in the AS1 district. The applicant requests a 43.5 foot reduction to the required 50-foot front yard setback to allow a setback of 6.5 feet from the east, which is the front yard lot line. The applicant also requests a 13-foot reduction to the required 15-foot side yard setback to allow a setback of 2 feet from the east lot line. No, I'm sorry, that should be the north lot line. I'll make that change in the report. The applicant is also requesting a side yard setback for the primary dwelling, which is the setback will be on the south side of the lot. Per Land Development Code 60101, a minimum side yard setback of 15 feet is required in the AS1 district. The primary dwelling on the lot, the applicant has a porch with a covered roof and encroaches into the required side yard on the south side of the lot. The applicant requests a 3-foot reduction to the required 15-foot setback to allow a setback of 12 feet from the south lot line. And the applicant is also requesting accessory setback for an accessory dwelling. Per Land Development Code 60102E, accessory dwelling shall meet principal building setbacks. Per Land Development Code 60101, a minimum rear yard setback of 50 feet is required in the AS1 district. The subject lot has an accessory dwelling that encroaches into the required rear yard, and the applicant requests a 12.8-foot reduction to the required rear yard setback to allow a setback of 37.2 feet from the west lot line. In terms of findings, per Land Development Code 60702A2, no fence exceeding 2.5 feet shall be constructed within the visibility triangle at roadway intersections as described in the Land Development Code, section 60403F, and includes the intersections of streets and driveways. The applicant has been informed that the fence height, design, and location must comply with these visibility requirements. Also, per Land Development Code 60101, a minimum lot size of 1 acre and lot width of 150 feet is required in the AS1 district. The subject parcel is approximately 0.54 acres in size and 105 feet wide. Therefore is non-conforming. However, the subject parcel has been determined to be a legal non-conforming lot per non-conforming lot determination 21-1100 and it's in the case file for this application. Subject parcel is subject of a code enforcement case which cites multiple violations and is included in the case file for this application. The applicant is aware that if granted the variance for the accessory structures in the front yard, they would be required to seek a building permit and comply with all requirements as determined by the building department for converting shipping containers into an accessory structure. That concludes my comments. I'm available for any questions.
Thank you, Mr. Beachy. All right, is the applicant here, please?
Wayne Wilson, 11648 Timber Ridge Drive, Tampa, Florida, 33625.
Thank you.
Patricia Murray, 11648 Timber Ridge Drive, Tampa, Florida, 33625.
All right.
We bought this property, didn't know all this stuff was out of order. We're just now, I put the containers out there and I put the fence up. Didn't know that I was doing anything wrong. So that's why we're down here trying to fix the problem. As far as the other mobile home that's on the property was there prior to us buying it. The porch on the back was prior to us buying it. So we didn't know that we was doing anything wrong. We just want to fix the problem and get people off our back, move forward with our lives.
Okay, so Mr. Wilson, do you reside at this property?
Yes, ma'am.
Okay. And what are these, the shipping containers and structures, what are they used for?
I use them to store stuff in them. I've got some toys and four-wheelers and tools and different things. Just use them to store stuff in. I've already been robbed since I've been there. Somebody stole a stump grinder that I own. It was $25,000 and we got it back, but it wound up down in Miami. Y'all have all that paperwork when we first started the code enforcement stuff.
And you placed the shipping containers on the property?
Yes, ma'am.
Okay. Is there anywhere else on the property they could be placed?
Not with where the property's set up, where the two homes are, and that's the most space I had over there in the left corner of the property. Not trying to do anything wrong, just trying to secure my stuff.
All right, and the 6-foot fence, is there, would it be possible to put a 4-foot fence there?
I would like to keep the 6 foot high. I really would. I've got a lot of money invested in that and a gate. Here again, I said we done got robbed once. You know, I don't want people coming. We live at the very end of the street. There's nobody else lives back there except her and I. You know, there was a 6 foot high fence when we bought the place. The place was in shambles, both homes, the property. We've done about 75% of the cleanup on the property, replacing stuff, fixing stuff and what have you. We didn't think putting a 6 foot high fence prior to being a 6 foot high fence there in the beginning. It was just old and rotten. We just put a new one up.
So there was a 6-foot high fence there to start with, and you replaced it with a
Yes.
new one?
Yes, ma'am. There's 7 or 8 places on that street that's got 6 foot high fences in their front yard. We're not the only one.
And what about the homes on the property? Are both of those occupied?
Yes.
So do you
One's a-
occupy them both, or do you lease one? or-
No. One's a granny shack and we live in the other one.
Okay,
Both of the homes was there when we bought it.
I understand.
You know, our fence actually was 15 foot on the county right away. We didn't know that. We did a survey and found out there was a lot of things wrong there. We didn't know when we bought it. Now we know.
Okay. All right, anything else? Do you
No,
want to-
ma'am.
Okay, all right, thank you very much. Please, both of you sign in with the clerk's office.
Yes, ma'am. Thank you.
All right, is there anyone here or online who wishes to speak in support of this item? Please come forward.
Good morning.
Good
My
morning.
name is Kong Fu, and I live in 7715 Garner Road. And I'm here just for support Mr. Wilson. I'm his neighbor, and I have no problem with his stuff in the yard.
I'm sorry, you have what?
I have no problem with his stuff in the yard. That's
Okay.
all.
How long have you been there?
2 years.
2 years?
Yes.
And do you recall there being a fence in place before he replaced the fence?
No, I not go down there a lot, so I have no problems.
Okay.
Yeah.
Do you recall the fence being there previously?
I didn't pay attention.
Okay, didn't pay attention. All right, understand. Anything else you would like to add, sir?
No.
Okay, wonderful, thank you. Please sign in with the clerk. Is there anyone else who wishes to speak in support of this item? All right, is there anyone here or online who wishes to speak in opposition to this item? All right, don't hear anyone, thank you. Development Services, anything further?
Yes, ma'am. I'd just like to take a minute to address the shipping containers. So the shipping containers, even if they're utilized for storage, and this was explained to the applicant, it's also in the staff report, constitute open storage. And open storage is not a permitted use of this property. Therefore, this variance, if approved, the applicant is going to, will have to obtain building permits for the shipping containers, at which point they become accessory structures. But of course, you wouldn't be able to get those permits without the variance, so setback variance. So that's why this comes first. Just want to make sure you understand, if you could acknowledge on the record and pull your mask up, please, that you understand that you'll have to obtain building permits for the shipping containers if this variance is approved, at which point then they become accessory structures and no longer constitute.
I'm fine with that. I already have an engineer to strap them down and whatever it takes to engineer them to stay there. That's,
Okay.
I'm perfectly fine with that. Yes, sir.
All right, thank you.
Thank you.
Thank you. All right, if the applicant has nothing further, this will close the hearing on item 21-0938.
All right, and next case is item H4, application 21-0958. The applicant is RU Project Management Group LLC, requesting a variance to accessory structure requirements and to lot development standards. Staff findings will be presented by Chris Grangillard.
Good morning. Chris Grangillard, Development Services. We're here to present application variance 21-0958. The applicant is requesting multiple variances to accommodate an existing screen enclosure on the front of a single-family home, an existing accessory structure on property zoned RSC 9. The first variance is for a screen enclosure per LDC section 6.01.01. The required minimum front yard setback in the RSC 9 district is 20 feet. The applicant requests a 2.2 foot reduction to the required front yard setback to allow a setback of 17.8 feet from the east property line along Church Avenue. The second variance is for accessory structure in the rear. Per LDC section 6.11.04, accessory structures 15 feet or less in height may occupy required rear yards, provided that such structures do not occupy more than 20% of the required rear yard and are not closer than 3 feet to the rear lot line. The applicant requests a 26% increase to the maximum permitted coverage of the required rear yard to allow a 46% coverage, and 2.5 foot reduction to the required rear setback to allow a setback of a half a foot from the west property line. Also in our findings, the screen enclosure on the front home does not conform to the front porch provisions found in LDC section 6.01.03.I.7 and therefore may not project into the required front yard. According to the applicant, the height of the accessory structure is 8.5 feet. That concludes my staff report. I'm glad to answer any questions you may have about it.
Okay, Mr. Beachy, just to be clear, under your findings,
Chris.
I'm sorry, Mr. Grand Leonard. I apologize.
Sure.
Under the findings, the screen enclosure doesn't conform to the front porch provisions, but that's what's necessitating the variance, correct?
Yes, ma'am.
Okay, good. All right. Thank you very much.
Thank you.
All right. Is the applicant here? Please come forward. Good morning. And you may pull the microphone down. Yes, please. Thank you.
Good morning, Ruth Londono, 1502 West Bush Boulevard, Suite D, Tampa, Florida, 33612. I'm representing the owner for the property, Liliana Marquez. Okay, we are requesting 3 variances. 2 of the variants, can I use the, okay. We are requesting 3 variances. 2 of the variances are for the accessory structure located on the rear yard, and the other variance is requesting for the front porch, a screen front porch. Maybe that answered the question that you have to the planner. I have some picture for that one that maybe be clear for you. Okay, that's the,
Okay, and there's a microphone right there. Thank you.
okay, that is the front porch.
Mhm.
The code allows to have a front porch in close to the front yard. If you see, the front yard is 24 feet, 0.6, but the screen porch, the front porch that is a screen, is inside the 20 feet, that is 17.8. The reason we need to request is because they have this little, can I use your pen? Yeah. The reason we need to request the variance is because the front porch has this little wall in here that made that be attached to the primary house and must meet the front setback 20 feet. Okay? And we are requesting the reduction from 20 to 17.8. According with some neighborhood, this house was built on around 1959, 1960s. In my record, apparently the owner has been talking with some of the neighbors. I have an affidavit that support the application, and this lady say that they remember that house has been there for more than 30 years in the front yard. I have another pictures that you can see around that property.
Ms. Londano, is that correct? When was the porch added onto the house?
I'm sorry, the what?
When was the porch added onto the house?
I have not the answer, exactly answer. What I was doing in my research is that maybe that was built together with the principal dwelling. I have no support to that one.
Okay.
And speaking with my customer, the owner for the house, she bought this house in October 2019, and that was there. And according with the owner for another property, this lady said that has been there for more than 30 years. I have another pictures that maybe you can look that. I was looking all around the property, and they have some other houses. They have the same porch. If you see, they have a front porches all in these areas and front porches on that areas. That is the reason that we need to request this one. Okay, the other two variances that we are requesting. Okay, maybe it's here, wait. Okay, if you can see this picture, that houses over there, they have the same. In all that area, I think that was built with the principal dwelling because in all that area is similar conditions. Okay?
Okay, thank you.
Okay, for the other variants, the other two variants that we are requesting are for the rear accessory structure. And we are requesting two variances. One for the rear setback, that is 3 feet. We are requesting to 6 inches. And the other variant that we are requesting is to increase the rear yard occupancy. The code says that we need to have only 20% occupy the rear yard. This structure is an occupancy of 46%. You need to understand that this lot is one of the smaller lots that is RSC9 district. The lot size 50 by 100. This lot has only 50 feet wide. That means that if you approve this variance, that got to be 46% occupancy, And you can see that one there. Yeah, that's a 50 feet wide. That's the 20 feet required yard side. And that's got to be occupied around the 46%. And the 3 and the reduction for the setbacks. If you have any question?
When was the structure built in the backyard?
Okay, I was looking on the record for Hillsborough County Property Appraiser, all the aerial photographs, and that's, I found that in 2006 was there, and that was the more far that I can go there with the aerial photograph. 2006, maybe that was built before 2006.
Okay. And the structure is, what is it constructed? Is it wood? Is it block?
It's wood.
It's wood.
It's wood. It's Can you see? Can we use this one again? Okay. Yeah, that's a wood.
Okay. And what is it used for?
They got to be used like accessory structure. One of the part got to be used for the gym, and the other part got to be used for storage. But that's got to be used only for accessory structure.
Okay. Doesn't have any living.
No, they don't go to have any bed.
Okay.
Or any sleeping areas.
Okay. Is there a kitchen or bath?
They have a bathroom for the gym.
There's a bathroom in the building?
Yeah, for the gym, for use with the gym.
I'm sorry, for use with?
Gym, the exercises.
Oh,
gym,
I understand. Okay.
but not for use for any, they cannot use for living. They cannot use for sleeping on accessory structure.
All right. All right, thank you. Is that it?
Thank you very much.
Are you going will you place those photographs in the record, please?
Yeah, I can provide that, and I have the affidavits.
And the
For
affidavits.
I have some affidavits for the neighborhood that supporting the application.
Okay, please
You want to see
place
those?
them with the clerk so they'll go into the record and I will see them.
Okay.
Thank you. All right, is there anyone here or online who wishes to speak in support of this application? Is there anyone here or online who wishes to speak in opposition to this application? All right, don't see anyone. Development Services, do you have anything further?
No, ma'am.
All right, thank you. And applicant, you don't have anything further to add, correct? Thank you. All right, this will close the hearing then on variance 21-0958.
Yeah, our next case is item H5, application 21-1094. The applicant is Karen Wagner. It's a request for a variance to accessory structure requirements. Staff findings will be presented by Tanya Chapella.
Good morning, Tanya Chapella, Development Services. This request is to allow a proposed detached workshop carport on a single-family parcel zone AR. Per the Land Development Code, Section 61104C1, accessory structures are permitted in front yards at twice the depth of the required front yard, or 50 feet, whichever is less. The required front yard setback in the AR district is 50 feet. Therefore, a minimum front setback of 50 feet is required for the proposed structure. The applicant requests a 47 feet, 10-inch reduction to the required front setback to allow a setback of 2 feet, 2 inches from the west property line. Variance application 20-1129 preceded this request, and a 3-foot setback from the west property line was approved for the subject structure. According to the applicant, an error made during the slab layout was discovered in the tie-in survey after the walls were erected. And this concludes my presentation. I'm available for any questions.
All right, thank you. Is the applicant here?
Yes.
Thank you. Please state your name and address.
My name is Karen Wagner. My address, I was told I didn't need to say is confidential.
Okay, thank you. This is regarding the property described in the application as 2,240 feet north of Thompson Road and east side of Bryant Road. Is that correct?
Correct.
Okay, go ahead.
I have typed out something so I don't ramble on explaining it. But next to me, I have my contractor, Bill Fenzu, and behind me, my husband, Daryl Wagner. My husband and I purchased 10 plus acres of vacant land in 2015 to build our retirement home. When we surveyed the land, we learned that our neighbor's fence was approximately 10 feet on our property. She promptly moved it for us, and we called it to her attention. In 2020, we were granted the variance to build an accessory structure, a workshop, 3 foot from the property line. We got that variance. Thinking that the fence was repositioned on the property line, our contractor poured the footer, a slab, and built the walls. Our contractor noticed at that point that the fence line looked a little crooked after having the lintels installed, and became concerned that our neighbor had not moved her fence to the property line appropriately, and asked us to get a tie-in survey and suspend construction at that time. We have attached the tie-in survey for your review in the packet. It revealed the building is 2 foot 2 inches from the property line instead of the 3 feet. We are seeking an additional variance to approve the construction as it was built by our contractor. If you have any questions, you can speak with our contractor. He's here. Our neighbor also acknowledged she placed her fence in the wrong location and has also signed a letter in support of our additional variance. She has been so kind as to also offer a couple of feet of her land if necessary. But after discussing that with Dennis Klein in the zoning department, he said it would be too expensive and more difficult to do that. And he suggested that we seek approval from the board, the variance board, to complete our build. Thank you for your time.
Okay. Thank you. What a mess, huh?
I know. A mistake.
Okay. Thank you very much. Is there anyone here or online who wishes to speak in support of this item? All right. Is there anyone here or online who wishes to speak in opposition to this item? Okay. Thank you. All right. Development Services, did you have anything further?
Nothing further.
Okay. Applicant, just forgot to ask you, you said you had something that was submitted to the record. Was that already submitted?
Yes, our neighbor's letter, saying that it was perfectly fine. She has a pasture there.
Okay. Thank you. Did you have anything else you wish to add?
No, ma'am.
All right. All right. Thank you very much. That will close the hearing then on 21-1094.
Our next case is item H6, application number 21-1121. The applicant is Jason Moss. They are requesting a variance to accessory structure requirements. Staff findings will be presented by Sam Ball.
Okay. Good morning, Sam Ball, Development Services. The applicant is requesting a variance to accessory structure requirements to allow for a detached garage and detached shed on a property zoned RSC3. According to section 611-4C3, an accessory structure that is no taller than 15 feet may occupy a required rear yard so long as the structures occupy no more than 20% of the required rear yard and are no closer than 3 feet to any rear lot line. The required rear yard on the subject property is 2,500 square feet, of which 500 square feet may be covered by accessory structures in accordance with the LDC. The proposed garage will be 1,750 square feet, 770 of which will be in the required rear yard. The shed to be replaced will also be 144 square feet, which will also be entirely in the required rear yard. The applicant is requesting a 16.56% net increase in the permitted coverage of the required rear yard to allow a total coverage of 36.56% for the proposed detached garage and existing shed to be replaced. That concludes my report. I'm available for questions. Thank you.
All right, thank you. Is the applicant here, please?
I'm Jason Moss, and I live at 1714 South Miller Road, Valrico 33594. And I'm just asking for the variance to, I have big dually trucks, and the house was built in 1978, and the attached garages are only 7 feet wide, which won't allow me to put my vehicles, which I have 2 of, or my boats, or the trailer that I have, into the garage to keep out of the weather and out of the animals that are continuously climbing on the vehicles. And then the other 144 square feet is for a shed, is to replace the dilapidated metal shed that was there originally. I'm building, both buildings are going to be contracted out and will match the house structure exactly. And will be no more than 15 feet tall. And they'll be made out of block, match the house.
I see. I'm looking at your site plan.
Yes, ma'am.
How do you get back there to the proposed garage? Is it?
There's an existing driveway that runs down the property line that will go right around, basically I'll drive right down the property line where the existing property line is right into the garage. If I pull them forward, I won't have the room to get in there because of my screen lanai of my pool. So that's why I'm asking for be pushed back to the 3 foot property line that what is allowed, but it's over the square footage, which I wasn't aware of when I designed it.
Excuse me, sir, would you please pull your mask?
Oh, sorry. Hold on, I'm sorry.
So you need a structure this big because of all the items you need to put in it?
Yes, ma'am. The 2 pickup trucks I have alone are 8.5 feet wide and 22 feet long. So to put 2 of those in there, it takes up half. And then I have a boat and a car trailer that I actually would like to put in there and keep out of the weather as well as away from the animals in the area. We have like feral cats, I guess, that the neighbor keeps, as well as raccoons and squirrels.
And you can't pull it forward because you say there's not enough clearance between?
No, ma'am, there's not enough clearance to make the corner. And I was gonna put it on the side of the house, on the side of the tree porch, but I realized that the property line has a 10-foot jog in it. When we originally bought the property, we thought it was a straight line, and we found out from my neighbor that the person that built the house bought the 10-foot from them to build the driveway.
Okay, anything additional you want to add?
The 144 square foot shed is replacing the existing shed that was there. And right now I pay $300 a month for a storage unit for the stuff that would go in there. And that's another reason I was asking to rebuild that and make it like more of a permanent, pleasant looking structure versus, a nasty old metal shed.
Okay, and is that one going to be block as well?
Yes, both structures will be built to code with the house. Will match the exact structure. Sophos Construction is the one actually doing the work, and they will be doing it's going to be done exactly to the code of the house, or the exact look of the house. And like I said, my neighbor's 2 houses down, he has his entire 3-car garage in his backyard, right up against the fence, and he has a 3-car. And the entire thing is back there.
All right, I'm just looking at the
Yes, ma'am.
application. The shed, the only variance related to the shed is related to the yard coverage. Is that correct? Is there a setback for the shed?
No, it's just because of it has to be added in because it's inside the 20% area that they require. So I was talking to Mr. Ball, and I had to include it in the actual garage, which I didn't know because it was already existing. I didn't know I had to do that. So I had to change the variance to include that.
Okay, I understand. All right, thank you, sir.
Yes, ma'am.
Be sure and sign in with the clerk here. All right, is there anyone here or online who wishes to speak in support of this application? Is there anyone here or online who wishes to speak in opposition to this application? All right, don't see anyone. Development Services, did you have anything further?
No, nothing further.
Okay. And applicant, you didn't have anything additional to add, right? Okay. Please submit anything that you have there with you, submit it to the clerk, and it'll get into the record. Thank you. All right, that will close the hearing then on 21-1121.
Our next case is item H7, application 21-1125. The applicant is Siddhikanta Panagrahi and Laura O'Connell, requesting a variance to fence requirements. Staff findings will be presented by Chris Grangillard.
Good morning, Chris Granlinard again, Development Services. I'm here to present application variance 21-1125. The applicant is requesting a variance for an existing fence and gate on property zoned RSC 6. The variance per LDC section 6.07.02.c.1.a. Fences over 4 feet in height shall not be allowed within required front yards in residential districts, except under certain circumstances that do not apply in this case. The applicant is requesting a 2-foot increase to the maximum permitted height to allow a 6-foot high fence within the required front yard, and a 3-foot increase to the maximum permitted height to allow a 7-foot high electric gate on the northeast side of the property along Westbrook Avenue. Per transportation review section, the single family lots swinging gate needs to be set back the length of a car parking space, 18 feet. However, the applicant's gate opens horizontally along a track south to north and does not require such a setback. I'll be glad to answer any questions you might have.
All right, thank you.
Thank you.
Is the applicant here?
Good morning. My name is Patricia Ortiz. I'm an AICP certified planner. I'm with Ortiz Planning Solutions, and my address is 2810 North Central Avenue, Tampa 33602. I am the representative of the applicant and the property owners. And this property is located at 402 Westbrook Avenue in Brandon, and that is just south and west of the intersection of Lithia Pinecrest and State Road 60. As staff indicated, we are asking for a variance to the code section he cited for what he described. Currently, there is a 6-foot tall fence in the front yard and a 7-foot tall horizontal slide gate in the front yard. In regard to hardship and practical difficulties, this lot is unusual in regard to its size, shape, and configuration. Most of the required front yard abuts the side yard of the adjacent properties. In green, I've outlined the front yard of the subject property, and in red is kind of where we are not meeting the code. Again, this property is located at the end of a dead-end road, and the fence and gate as located prevent that unwanted glare from oncoming traffic and protect the property. I do believe that this request is in line with the spirit of the code, which aims to protect personal property, assure safety and security, and enhance privacy while, of course, maintaining visual character. Again, the unusual size and shape of the lot with the home located right in direct line with the roadway prevents a hardship here. I don't believe that this request interferes with the rights of other property owners, as the fence is located right on the property line for most of its, location in the front yard, and those adjacent property owners would be allowed a 6-foot fence if it were just on the opposite side of the property line, because that would be in their side yard where a 6-foot tall fence is allowed. And I'll just conclude by saying this does come to you as a result of a code enforcement violation. The electronic gate was installed without a permit, but the property owner is in the process of securing the after the fact permit, and I'm working with code enforcement on that on his behalf. I do think that the land development code and the comprehensive plan work in conjunction to protect or to provide a balance between the rights of individuals in regard to privacy and security and the public's right to a pleasing aesthetic, and that the end result here is in line with both the intent of the comp plan and the code. And I can answer questions you may have.
Just a quick question to clarify the height of the fence across that whole front yard. And I understand the front yard abuts what is actually the side yard of the neighboring properties.
Correct.
Is the fence 6 foot high all the way across there?
The fence is just in line with those two columns. So the fence is 6 feet tall. The gate is mostly 6 feet tall, but at the peak, it becomes 7 feet tall. And let me just correct that. There are 2 lanterns on top of those columns. They have a maximum height of 7 feet as well.
Well, is the variance for the height of the fence all the way across the front yard?
Yeah, well, I think so, if I understand your question. The fence is 6 feet tall, but the gate is 7 feet tall.
It's higher. But doesn't the fence need a variance because it's, Mr. Hisney, maybe I should ask you that question?
I think both the fence and gate need a variance, and perhaps a neater way to have packaged this would be to have said a maximum height of 7 feet.
Okay, so no, I think that's right. I specifically the fence.
Madam here.
Thank you, Mr. Hisney.
In the paragraph that summarizes it, it actually does break it down into 2. It describes a 2-foot increase for the fence height to allow a 6-foot high fence and a 3-foot increase to the permitted height to allow a 7-foot high electronic gate.
Okay, thank you. That clarifies it. Yes, I understand.
Anything further?
I have no further questions for you. Thank you. Is there anyone here who wishes to speak in support of this application? Anyone here or online in support? No. Is there anyone here or online who wishes to speak in opposition to this application? Don't hear anyone. All right. Development Services, anything further?
No, ma'am.
Okay. Applicant, anything further? No, thank you. Okay. That will close the hearing then on variance 21-1125.
Well, that concludes the variance portion of our agenda today. It now takes us to section J, which is special uses. The first item, J1, was special use application 21-0375. However, at the start of today's hearing, this case was continued to the October 25th Luho meeting, which then takes us to item J2, special use application 21-1003. The applicant is Miguel Ramos. They're requesting a 2 COPR alcoholic beverage permit, which requires a separation waiver. Staff report and recommendation will be presented by Tim Lampkin following the applicant's presentation.
All right, thank you. Applicant, please come forward. All right, state your name and your address, please.
My name is Joanna Daskalopoulos, 2188 Hartford Way, Clearwater, Florida, 33763.
All right, and
this is Miguel Ramos.
My name is Miguel Ramos.
Okay, you're the property owner?
The restaurant.
The applicant?
He is the restaurant owner.
Oh, thank you. All right.
We are here to try to get a 2 COPR beer and wine license.
All right, be sure and speak into the microphone, please. Thank you.
Okay. And we needed a variance regarding, there's a community use within 500 feet. We have pictures to show That is, there is extensive buffering between the restaurant and the church. There's a retention pond that is approximately 7 to 8 feet wide between the restaurant and the church. There is a concrete wall and a barbed wire fence. There is also a storage facility between us and the church. And when you leave our premises, Miguel's premises, the restaurant, El Caribeño restaurant, you must take a right turn from the building and take a right turn on Hillsborough Avenue and then make a U-turn before you get to the church. We have pictures showing the retention area, the barbed wire fence, the right turn, the extensive traffic, making a left U-turn in order to get to the church. There was also, for the last 30 years, a beer and wine license on this premises. However, I guess there was a mapping error somewhere along the line, and it came up at this time.
Okay. Do you want to show, do you want to display those photographs? There's an overhead there, and then you can point out what you're describing. And there's a microphone there that you can use as you speak about the photographs.
Okay, and how do you do this? Sorry.
And you can turn that the other way. There you go. Thank you.
Okay, this is the restaurant, and the only way in and out is right through here.
Mhm.
Hillsborough Avenue is right in front of the restaurant, which would be right here.
Mhm.
You would have to take a left turn to go on to Hillsborough Avenue. This is the view of the retention area.
Okay, move it over just a little bit, please. So it shows, there you go. Thank you. So that,
Between us and the storage facility, which is quite, it goes from here, well, basically to here.
okay.
This is another picture of the retention area, which separates us not only from the church, but from the storage area that's between us and the church.
Okay.
This is a little bit closer to the storage area between the restaurant and the church, showing more, I guess, foliage or lawn or whatever is there between us. This is a picture of the restaurant right here, the retention area right in this area, and then the storage facility right there. This is actually the barbed wire fence. And they have on this side a brick wall separating the restaurant from the storage facility.
All right, and the fence is for the storage facility?
Correct.
Okay.
The brick wall is actually between us and the storage facility, and then the barbed wire fence is between the storage facility and the church. And it is public storage, so it is quite a wide building. Here is one more picture of the barbed wire fence between our restaurant and the public storage.
Could you bring the microphone down just a little bit, please? So, thank you.
Okay, thank you. And again, another barbed wire fence, just different views of it, showing the separation of us and the storage facility. And then the church is on the opposite side of the storage facility.
Mhm.
This is an actual picture of the church. And they have in front of the church a small retention area, but it's mostly cleared just to accumulate water when it rains. But that's another dividing issue between us and them. And if you could see here, The church is right here, and this is public storage, and we are on the other side of public storage by the green sign.
Okay.
Again, a bigger view of where the church is and where we are, all the way down there. And I've only got two more. All kinds of equipment that is on the church property, on the storage property, and signage everywhere between us and the church to give it a buffer, basically. This vehicle is exiting and about to head the other direction. This is the front of the restaurant. The only way they can head east is to come out, turn right, make a U-turn at this point and head east. And the church is all the way down on this section here. And this is just another picture of all the traffic and the restaurant to the right of us, which had a beer and wine and liquor license, and since has closed, they do not plan to reopen. So this is the traffic heading west, and then they have to make a U-turn to head east to get to the church. And again, this is El Caribeño Restaurant, and the church is all the way down here with the storage facility in between. And this is actually the front of the church. The front door of the church is all the way over here, and our restaurant is all the way down here.
All right, thank you. Are you able to submit those photographs in the record?
Yes,
Okay.
absolutely. And sorry, I made a mess. I wasn't watching the screen. I was just watching the pictures down.
That's fine. You've got plenty of time.
Okay.
So it might have been mentioned, but what is the distance between the restaurant and the church?
Basically, it says that we need a variance of 201 feet. I'm sorry, 199. The church is 201 feet from the property.
Okay.
But there's also a picture, and I think you might have this already, that shows that an aerial view of the restaurant to the church, anticipating the right turn out of the restaurant, making a U-turn, going left, is actually 650 feet away.
Okay, I see it. Yes, thank you.
It reflects the intent of the code and actually exceeds the intent, but it's not, as they say, the bird flies, or however that is.
I understand.
I also have copies of licenses that were on the premises for beer and wine as well. And I can submit all of them. And the licenses have been there, and it was only for beer and wine for the restaurant for the last 30 years.
Okay. All right, thank you. Anything further? Yeah.
Not at this time.
Okay. And be sure and sign in with the clerk and just submit all of the photographs and documents to the clerk, and they will get into the record and I will see them.
Did you also want the beer and wine licenses from the past?
If you have them and you would like to submit them, please do.
I have them only for like the year 2011, 12, 18, and 19. I couldn't find the rest.
Okay.
But they did go back to 2001 when I owned the restaurant, and they went back another 10 years before that when the landlord owned the restaurant.
I see.
And it all came up now because of a mapping error from before.
Okay. So you owned the restaurant before and you had the licenses
Yes,
before?
yes.
I see.
And we served food. We served breakfast, lunch, and dinner, and Miguel does as well. He serves breakfast, lunch, and dinner. So the food would be probably guaranteed more than 51%, but probably 75, 80%. And then the beer and wine would be, maybe 15, 20%, just as a convenience to the customer with their lunch and dinner.
Okay. All right. Thank you very much.
Thank you.
All right, we'll hear from Development Services.
Good morning. Tim Lampkin, Development Services, here to present the item. Per section 6.11.11, this request is for a distance separation Waiver.
Mr. Lampkin, we can't hear you very well. Could you get your microphone a little bit closer, please? Thank you.
Let me check my sound. Might be, I can hear you through the headphones, but I have a feeling it's going to my laptop. Just up the sound. Is that better?
I think so. Thank you.
Okay, you're welcome. All right, so starting over, Tim Lampkin, Development Services, per section 61111, the request is for a distance separation waiver for 2 COPR, alcoholic beverage permit for the sale and consumption of beer and wine on and off the permitted premises in connection with a restaurant. At least 51% of the restaurant's total biannual sales shall be derived from the sale of food and non-alcoholic beverages. This property is located at 8425 West Hillsborough Avenue. The wet zoned area will comprise a footprint of 2,539 square feet of indoor area and 747 square feet of outdoor area for a total area of 3,286 square feet as shown on the revised wet zone survey. Per section 61111D.4, the following distance separation requirements apply to the proposed wet zoning. The first is the applicant needs to be at least 150 feet away from residential zone property, and the applicant meets that requirement. The second is the applicant needs to be with over 500 feet from community uses. They are within 500 feet of a church. The proposed wet zoning is 201 feet from the property occupied by the church, and the applicant requests a 299-foot waiver to the required 500-foot separation. Staff finds the following. Per section 6.11.11.E.3, which provides for the approval of separation waivers where there are special or unique circumstances and where the alcoholic beverage use applied for does not have significant impacts on surrounding land uses in certain circumstances, negate the necessity for the specified distance requirements. Number one, the pedestrian route of travel from the entrance of the restaurant to the entrance of the church is approximately 650 feet. As the applicant had shown in the photographs, property is located on West Hillsborough Avenue, which prevents direct vehicular access from the restaurant to the church property because it is the opposite direction of the church and it has right turn out only. As the applicant showed in the photographs, the proposed wet zoning is separated from the church by a mini warehouse storage facility, which creates an effective buffer between the wet zoning and the church. Proposed wet zoning is requested by an established restaurant, and the 2 COPR category is restricted to restaurant use, which requires that a majority of the annual sales be from the sale of food and non-alcoholic beverages. Therefore, staff finds the addition of the beer and wine sales do not represent a substantial change to the existing restaurant use, and based upon the reasons discussed above, staff finds the proposed wet zoning does not pose significant impacts on the church or other surrounding uses.
All right, thank you.
Yeah.
All right, is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Anything further from the Development Services?
Nothing further.
All right, thank you. And applicant, did you have anything further you wish to add? All right. All right, thank you. Well, then that closes the hearing on special use 21-1003. Thank you.
All right, our final case today is item J3, special use application 21-1124. The applicant is Northdale LLC. The request is for a 2 COPR alcoholic beverage permit, which requires a separation waiver. Staff report and recommendation will be presented by Tim Lampkin following the applicant's presentation.
All right, applicant, please.
Good morning, Madam Hearing Officer. My name is Joseph Diaz.
I need you to keep your mask on, please, Mr. Diaz. Thank you.
My offices are located at 3242 Henderson Boulevard, Suite 310, Tampa, Florida. I filed this application on behalf of the applicant, Northdale LLC. As was pointed out, we are requesting a 2 COPR, which would allow for the sale of beer and wine for consumption on premises as well as off premises for package sales, but would require that at least 51% of the sales of the establishment come from non-alcoholic sales, be they food or non-alcoholic beverages. The subject site is located within a strip center that is located on the north side of Northdale Boulevard and consists of approximately 1,129 square feet. The designation that we are seeking requires 2 distance separation. One is that we not be within 150 feet of residentially zoned property, and the other one is that we not be within 500 feet of certain community uses. We satisfy the residential separation. It's the community uses that we are requesting 4 waivers on. The front door of the business establishment faces in a southerly direction. And to the west and north of the establishment on Mapledale Drive, there is a church and there is a child care school facility. All of those, or both of those locations have structures, developments between us, as well as landscaping and what have you. And for you to be able to access either one of those locations, you would need to come out our front door, go down to Northdale Boulevard, hang a right, which would put you going in a westerly direction. And then when you get to Mapledale Drive, hang another right, going in a northerly direction. I think that if you look at the staff's report, you're going to see that with respect to the child care center, we're some 1,200 feet away, and with respect to the church, we're some 1,300 feet away. Another separation that we have is respecting a child care center that is located on Premier Boulevard. The site is located roughly in the middle of this retail center. And by the time you come out the front door, access the normal pedestrian route of traffic, cross Premier, go down in a northerly direction in Premier, you're going to be some 550 feet away. And I think we would once again then satisfy the distance separation. The last one involves a county park, which is located on Spring Pine Drive. To access that facility, you would have to cross a 4-lane road, which is Northdale Boulevard. Then you'd walk down the sidewalk, and by the time that you got to the actual facility yourself, you're some 700 feet away. So we would suggest that given these normal routes of pedestrian traffic and the fact that when you follow them, we exceed the 500-foot separation requirements, that we do not create any kind of a problem. And given the unique situation, that we would ask that you humbly approve our application. Staff has apparently concurred with our application and have found the application to be approvable. And we would, of course, adopt that.
Okay.
Any questions?
I have none for you, Mr. Diaz. Thank you.
Thank you.
Please be sure to sign in with the clerk. Is there anyone here who wishes to, oh, no, Development Services, I'm sorry. Development Services first.
Hello, can you hear me okay?
Yes, can hear you fine, thank you.
Okay, good. This is Tim Lampkin, Development Services, speaking for application 21-1124. For section 1111, the request is for a distance separation for a 2 COPR, alcoholic beverage permit for the sale and consumption of beer and wine on and off the permitted premises in connection with the restaurant. At least 51% of the restaurant's total biannual sales shall be derived from the sale of food and non-alcoholic beverages. The property is located at 3889B Northdale Boulevard. The wet zone survey area will comprise a total area of 1,129 square feet as shown on the wet zone survey. Per Land Development Code section 6.11.11.d.4, the following distance separation requirements apply to the proposed zoning. Number one, the distance separation of 150 feet from residential. The applicant complies. Number two is the distance from the proposed structure to certain community uses must be 500 feet, and the application does not comply with this. They're requesting 4 distance separations from 4 community uses. Number one, the proposed wet zoning is 478 feet from a property occupied by a church, Northdale Lutheran, located at 15709 Mapledale Drive. Number two is the proposed wet zoning is 396 feet from a property occupied by a school located on Mapledale Drive and associated with Northdale Lutheran. 3, the proposed wet zoning is 357 feet from Northdale Park, located on Spring Pine Drive. And 4th and lastly is the proposed wet zoning is 224 feet from a property occupied by Kindercare located off of Premier Drive. Staff finds the following. LDC section 61111.E.3 provides for approval of separation waivers where there are special or unique circumstances where the alcoholic beverage use applied for does not have significant impacts on the surrounding land uses and certain circumstances negate necessity for the specified distance requirements. Regarding waiver 1 and 2, the Northdale Lutheran Church and Teat Academy, front door entrance for the public faces south away from the church and school, which is located to the north and west of the proposed wet zoning. It should also be noted that the normal route of pedestrian and vehicular travel between the proposed wet zoning and the church and school well exceeds 500 feet. Waiver 3, the 143-foot waiver to the required 500-foot separation from Northdale Park. The proposed wet zoning is located at the east end of the retail shopping center and its front door faces the southeasterly direction, slightly away from the park. The park is located southwest across a 4-lane roadway. And as the pedestrian travels, it's approximately 700 feet away, or as the car travels. Waiver number 4 is a request for a 276-foot waiver to the requested 500-foot separation from a child care center, Northdale Kindercare, to allow a 224 feet separation from the church property line. Staff finds the proposed wet zoning is located towards the center of the building and is buffered by the east wing of the existing structure, creating some additional distance. It's also noted that following the pedestrian sidewalk, and if you cross the Premier in the middle of the road, it would approximately be 550 feet, or if you're in a car and you're turning left across a Premier, exceeding the 500-foot distance separation. In conclusion, proposed wet zoning for the 2 COPR category is restricted to restaurant use, which requires that a majority of annual sales be from the sale of food and non-alcoholic beverages. Therefore, staff finds the addition of beer and wine sales does not represent a substantial change to the existing restaurant use. For the reasons discussed above, staff finds the proposed wet zoning does not pose significant impacts on the community uses and other surrounding land uses. Staff finds the proposed 2 COP wet zoning approvable. This is based upon the wet zone survey reflecting a total wet zone footprint of 1,129 square feet received on July 27th, 2021. That does conclude staff's presentation unless there were any questions.
I have no questions for you, Mr. Lamkin. Thank you. All right, is there anyone here or online who wishes to speak in support of this application? All right, is there anyone here or online who wishes to speak in opposition to this application? Don't see anyone. All right, Development Services, anything further?
Nothing further.
All right, thank you. Applicant, anything further? Nothing further. All right, thank you. So that closes our hearing on 21-1124. And I believe that closes our meeting for the day.